Now let's move to the discussion. Our discussants today are Professor Seokwoo and Judge Maurice KAMGA. Professor Seokwoo is a professor of international law at the Inha University. He co-chairs International Law Association study group on Asian state practice of domestic implementation of international law. Among his other functions, Professor Seokwoo is a general editor of Encyclopedia of Public International Law in Asia, co-editor-in-chief of Asia-Pacific Journal of Ocean Law and Policy and Asian Yearbook of International Law. Among numerous publications of Professor Seokwoo, I would like to mention in particular chapters on deep seabed activities and Korean law in the book called The Maritime Environment and United Nations Sustainable Development Goal 14, published in 2018, and on climate change and sea level rise in the essays in honor of David Freestone, published this year. Judge Maurice KAMGA is a member of the International Tribunal for the Law of the Sea, good colleague of mine. His previous professional experience includes service for the Cameroon Ministry of External Relations and several prominent international institutions for several years. He was a legal secretary of the International Court of Justice. Judge KAMGA has vast experience teaching international law, which he continues to do as an adjunct professor at the Catholic University of Lille. His publications on international law include in particular articles on legal principles applicable to the exploitation of transboundary offshore oil and gas fields, in the African Yearbook of International Law of 2017, and on the legal aspects of maritime migration, published in 2020 in the Journal of the African Union Commission on International Law. Whom shall I give the floor first? Maybe Professor Seokwoo.
Thank you. Thank you very much. Maybe let me begin with express my special thanks to the organizer of this conference, the Ministry of Foreign Affairs Korea, International Tribunal for the Law of the Sea, and also the Korean Society International Law to invite me to part of this program. This conference is the 6th year, and looking back to the previous conference briefly, as I recall correctly, the first time we touched upon the various island sovereignty issues and the dispute settlement mechanism of the convention, because at the time the key issues, key agenda was the South China Sea arbitration. And then we had a chance to review that the various cases delivered by the tribunal, which makes us that the contribution of the tribunal for the jurisprudence of the law of the sea. And from the 2 years ago, we're working on the more global level, which is a new development. The mainly touch upon the various agenda of the maritime marine the environment. From my own perspective, the most important contribution from the tribunal indeed is a protection or preservation of the marine environments. They provide the in-depth and breadth, the various corners of that issue, and that gave us the the new issues. Right now we're working on like a deep seabed mining, or the climate change, or the BBNJ, or also the art issues. Today, the first session, as we share that the two papers on the aerial drone and also the MAVs, which is based on the new technology, and also the third paper is on the deep seabed mining issues. I pretty much interested to lead those papers and presentations. Let me touch upon the first two papers, then move to the third paper. The first two papers, before touch upon the first two papers, I want to share that the current situation of the Korea, because that new technology we're talking about, this let's say aerial drone or the MAVs, it's a new technology. But it's not actually quite new, because from the Korean perspective, in particular, where the Korea located in Northeast Asia, it is quite easily witnessed from the law enforcement agencies. So when you have a chance to see those ones, because in Korea located in Northeast Asia, except a very few limited area in southern parts of Korea, there is no fixed maritime boundary with our neighboring states. Unfortunately, Korea is surrounded by the major ocean power of the world. This is really unfortunate for Korea. China, Japan, Russia, and North Korea. And with a very limited area we share, let's say the semi-enclosed sea, which means that inevitably we have to maintain or we have to manage the overlapping area with our neighboring state. The problem is that when you have a talk with this drone, aerial drone, or the MAVs with the law enforcement agencies, the difficult issues we receive from the field officers that are largely two issues. They cannot identify which nationality or the ownership of the vehicle and what is the function of those instruments. For example, let's say we're talking about the immunity or liability, but before that, the most important is that the linkage of that instrument to the nationality of those one. Sometimes they cannot. Coast Guard and Korea cannot define that where the instrument, the vehicles or aerial drones and the MAVs came from. Even if they found, they cannot know what function they are conduct in Korean domain. The second issues come up is that the area they found, as the Professor KLEIN present in her paper, if that things happen, found in a territorial sea, I don't think that there is an issue. But if the things happen in easy or overlapping area, that is quite sophisticated issues for law enforcement agencies. Indeed, in practice is that even if found in the overlapping area or EEZ, if that proven to be with reasonable doubts, beyond reasonable doubt, that is conducts the marine scientific research, Korean Coast Guard can apply the domestic legislation on EEZ Act. However, if that is not clear, what kinds of function or the role those instruments can play, conduct in Korean ocean domain, the job of the Korean agencies of the law enforcement have to do, or only can do, is that refrain from the exercising of our sovereignty or sovereign rights. So that after having heard that the two papers, an aerial drone or the MAVs, what I think about the two things I really want to share my personal perspective is that the identification of the vehicles is very much important. Although it's too much expect that the smugglings or the traffickers has those identification by nature. However, if the identification is clear from our point of view, it is very much necessary to the second stage of find out what is role and function. It can be espionage, it can be conducted to military purpose, and then the Coast Guard, the Korean law enforcement agencies think about what kinds of the measures they can apply. But in practice, it is highly difficult to find out what kinds of role and function those vehicles conduct in Korean domain, in particular the EEZ and the overlapping area, and that go beyond the identification issues. If those are not clear, for example, there is no identification of the vehicles and they're not sure about the role and function of the vehicles, I believe that the coastal state can exercise some of the sovereign rights in terms of disposal of that equipment. Otherwise, due to growing number of new technology, give us the highly proliferation of those facilities in our Korean domain, which is quite detrimental to Korean safety and security. As you know, that not only in terms of the safety and security, but also the Korean seaborne trade is more than 99%. So the whole economy is rely on the seaborne. So keeping the maritime order is very much important for Korea. So if I summary of my comments of the first and second question, second presentation today is that the identification and also the clarification of the function of the beakers should be proceeded before the coastal state can act in terms of disposal of those the beakers. So hoping that the state practice to follow, and as I mentioned, the Korean domestic legislation do not has any the term of these aerial drone or the MAVs in a domestic legislation. Hoping that the Korean domestic legislation reflect these developments into the current legal regime, so that that will be enhance the condition of the surveillance of the Korean domain. I believe that there will be applied the other part of the world. Actually, the third paper is quite interesting. What I hear here is that I just remind me when I'm working on that the other papers, other subjects like human rights or environmental issues. It reminds me that the many transnational corporations conduct in a certain part of the Africa or Latin America. They prove that the mass destruction of the environments or human rights violation. And the same things, I think the same situation applied to deep seabed mining in the area. And whenever I have these deep seabed mining issues, just remind me that one of the most important, the advice opinion delivered by this tribunal. We know that the 2011, the tribunal provided very the specific advice opinion on the responsibility and obligation of state with respect to activities in the area. Actually, that case, as you know, that the report from the Inter-Seabed Authority to the tribunal, and the tribunal provided very detailed guidelines the state parties have to follow. I believe that if we go to that, the specific obligation provided by that, the advice opinion, we see that the more promising the future. However, as the presenters mentioned that there are intertwined two issues. The first is that the benefit sharing and the profit rate for the private, the actors are increased, and eco-friendly environment, the protection, preservation demand is going higher. So how they can balance these two interests is quite the important one, together with the high technology developed for that. In Korea, we have some movement in the 2018. There is a domestic law which was not passed at the time by the certain regions. And this domestic law on deep seabed area has a quite distinctive article which provide obligation of private activities engaged in the area. Private entities engaged in the activities in the area. I do not hear that the act will reintroduce again, but hoping that I was before I come here, I contact the ministry. They planning to apply, resubmit this act next year. So again, the domestic legislation on this issue enhance the visibility of what we have to see in the future, and that if we have some state practice in this regard, including that the post-exploitation stages, discourses included, there will be very much see that what we face with the new technology. So I think I have a couple of things to say more, but due to the time constraint, I have to stop here. And thank you very much again for the wonderful presentation from the overseas and the participants, the presentations here. Thank you very much. Thank you.
Thank you very much, Professor Seokwoo. Judge KAMGA, what would you like to to say? What would you like to add? And I would like to know from the organizers, how much time do we have? How much time is left for our panel? Because I would like to have a possibility for our panelists to react to the valuable comments that were made. Could somebody tell me how much time do we have?
We do have 15 more minutes for this session.
Okay.
Thank you.
Thank you so much. Judge KAMGA, please, you have the floor.
Thank you, Judge KOLODKIN, for giving me the floor. I will join my voice to the previous speakers by expressing my gratitude for the organizer for this conference, for the opportunity they have given to me to participate to this exchange of views on the impact of the newest technologies on one of the oldest branch of international law, that is the law of the sea. In fact, with the current stage of development of technology, it is very important to examine to which extent the existing international order in general and the law of the sea in particular can address the challenges posed inter alia by aerial autonomous vehicles which can be used for maritime surveillance, or by maritime autonomous vehicles which can be used for security purposes at seas. We have just heard two brilliant presentations on these issues, as well as a third one, equally brilliant, on the regulation of deep seabed mining beyond national jurisdiction. I have to confess that it is rather difficult to take the floor after these three expert presentations on topics which are very technical for me. Off recall, I have to say that I did law because I was unable to do anything in science. I wanted to do science, but they told me that my capacity was too low to do science. Now I did law, and now I'm meeting science again. But I will try to make some observation and comments about what had been said. From what we have heard, it is clear that we are in a period of great uncertainty concerning the applicable law with regard to new types of vehicles which were not foreseen by the drafters of the United Convention on the Law of the Sea less than 50 years ago. In fact, while the prospect of unmanned and/or autonomous vehicles on or above the sea was considered rather unrealistic a couple of decades ago, the debate now centers on what format and pace the development of these new engines will take place, as well as to what extent they can be regulated by the existing law or the future law. It is clear from the presentations that the regulatory discussions is just emerging, while many new questions have been raised and very limited clear answers are available for them to date. Concerning the issue of aerial autonomous vehicles used for maritime surveillance, there is a clear interference between international air law and international law of the sea, and the international community will have to find a solution on this new issue, as Professor NORODOM has shown in her presentation. In the recent past, there has been a huge interest in developing areas autonomous vehicle, not only for maritime surveillance, but also for civilian purposes, and the necessity for the clarification of the applicable law is more than urgent. With regard maritime autonomous vehicles used in the field of maritime security, the primary difficulty is related to the classification of those vehicles as vessels or ships, or even as warships under the current international law. In this regard, the presentation of Professor Natalie KLEIN has shown that, once again, it will be difficult to apprehend the problematic of the maritime autonomous vehicles and the international maritime security law without referring not only to the classical law of the sea, but also to other relevant international treaties and even to national law. In this regard, it is interesting to see that the International Maritime Organization has recently indicated, I quote, that it wants to ensure that the regulatory framework for maritime autonomous surface ships keeps pace with technological development that are rapidly evolving, end of quote. So the issue of terminology is really important here. I have tried to read some articles on the issue, and it was very difficult for me to make a clear distinction about the different expressions used to qualify maritime autonomous vehicle. We saw on one of the slides how many expressions are used. But one can also ask a question about the difference to be made between maritime autonomous vehicle and military submarine. It is difficult to know what is going in the submarines. So it's obviously difficult to know if there are men in the submarine or not. What would be the qualification of such a submarine without men on board? Some question can also be the issue of visit with those vehicles. How can a vehicle visit concretely a ship? Can a vehicle go on board and try to have questions or not? The issue of hot pursuit is also here important. Can a vehicle arrest people in in a ship? What will be the case if we have two autonomous vehicles? One is trying to search another vehicle, or one is trying to arrest another vehicle. So we see that we have really problems here which has to be solved. To conclude my intervention, I will conclude my intervention by saying a few words about the topic of the regulation of deep seabed mining beyond national jurisdiction. The International Seabed Authority has the mandate received from the 1982 Convention to organize, regulate, and control all mineral-related activities in the international seabed area and for the benefit of mankind as a whole. In this regard, it is not only vital that any contractors wishing to undertake mining operation in the area will need to abide by the regulations established by the International Seabed Authority, but it is equally important that new technologies be used not only for a coherent and effective safeguard of the environment, the marine environment, but also in a transparent manner in order to meet the historical expectations embodied in the principle of the common heritage of mankind. In sum, the technological advances of certain states or certain international actors should not break the promise that the resources of the seabed should be exploited for the benefit of all the human beings in our fragile planet. I will conclude by saying that from this presentation, we can see that we can have a new feel for the revival of the law of the sea. I have noticed, in particular in French-speaking countries, that you barely have now courses about law of the sea. I see that with the new technology, we can have many new PhD dissertations which can be treated by the student, and we then have a new fertile field for research in the law of the sea. Thank you very much.
I thank Judge KAMGA for his valuable comments. May I ask our panelists who would like to react on to what was said. Professor KLEIN, please, you have the floor.
Thank you, Judge KOLODKIN. But in view of the time, I'll just make a couple of brief observations. First, to thank the two discussants for their very thoughtful views. And I think Professor Lee, I just wanted to emphasize, I think raises a very important point in relation to the functions of the different maritime autonomous vehicles. I think that is very much going to drive how we see the law developing. So there's not going to be one size fits all approach in this regard, because necessarily the vehicles themselves are so different. So I do think that's an important point to highlight. And I thank Judge KAMGA for really emphasizing the diversity of issues that we need to consider when we're dealing with maritime autonomous vehicles. But even in the face of new technology, I think we can also recall that UNCLOS does still provide us with a very strong starting point, and I think there is much still to be gained from our existing law when we're dealing with these new technologies, rather than necessarily thinking we have to go too far in reinventing law just because of the new technologies, though that is not to discourage anybody from any PhD proposals that want to look at these new forms of technology. And it did just make me think in relation to Professor Kim's paper, which I very much enjoyed, thinking about how much changes when we're thinking about laws relating to intelligence gathering, when a vessel is uncrewed or not. Some of those questions seem to be equally relevant, irrespective of whether there's humans on board or not. So I think that's still going to be an interesting point to tease out, but I'll leave it at that, and I'm very happy to follow up with anyone on email, since I don't have the benefit of a chat over coffee afterwards, for someone to get in touch if they're interested to follow up. Thank you.
Professor KLEIN, thank you so much. Dr. DINGWALL, probably?
Yeah, thank you. If I could just make one brief remark, also conscious of time. Thank you so much to Professor Lee and Judge KAMGA for the very helpful remarks and insightful remarks on our presentations. I think just to follow up on the point about the importance of this new technology in deep seabed mining, I think one thing in particular is that as technology continues to develop, it's going to be very important for the mining regulations to have a degree of flexibility in them, so that they can always encompass the best environmental practices in terms of using the technology that will cause the least harm possible. So I think that is something we're seeing the ISA working on just now, in terms of trying to finalise the draft exploitation regulations and have certainty, while at the same time allowing for the evolution of the regime as technology continues to develop. And they're doing this in part through the idea of the standards and guidelines that will accompany the draft the exploitation regulations. And similarly, very happy to follow up by email, because I also wish I could be there in person, but happy to take any questions by email later. Thank you.
Thank you, Dr. DINGWALL. Dr. Kim, would you like to add something?
Yes. First of all, I am very grateful to Professor Lee and Judge KENGNE for insightful comments and feedback. Just like maritime autonomous vehicles, there are many terms to designate aerial drones. So as I show you on the slide, the UAS, UAV, RPV, and RPAS. So there are several terms, but I already stressed I highlighted that regardless of their names, their essential is an unmanned system. But however, I would like to say that there is a difference between UAV and RPAS concepts because the first one, the UAV, refers to the aircraft alone. However, the RPAS, remotely piloted aircraft system, refer to global architecture of the system in a holistic manner. So there is a slight difference. Yeah, thank you.
Thank you so much, Dr. Kim. I believe we exhausted our time and even were a bit too long, but we apologize for this. It's probably my poor moderating of the panel. The reason of that. Thank you so much. I would like to thank the participants and the audience. And once again, I would like to thank the organizers for having me at the conference and wish the conference every success. Thank you so much.
Thank you very much, Judge KOLODKIN, for moderating this session. And thank you very much to all the participants for sharing their insights and experience. Let us give all the speakers a big round of applause again. Thank you.